And so, Dr. Abraham, if you would simply provide a very
Yes,
brief.
this is Dr. Abraham. I'm dealing with a family emergency and I'm in the hospital right now.
Okay. And so I'd like to lay a motion upon the floor, upon the table, as it were, to allow Dr. Abraham to participate remotely pursuant to the emergency circumstance of the California Government Code provision vis-a-vis the Brown Act.
I'll make such a motion.
Is there a second? Well, yeah, I moved it, so essentially you seconded it. Mr. Pearman, second. Any further question or discussion on that motion? Hearing none, Ms. Verdugo Peralta? You're on mute, Ms. Verdugo Peralta.
Oh, boy. She's still mute.
Okay, there we go. You're unmuted.
Aye.
Okay, Dr. Abraham? Dr. Abraham? Sir, can you hear us?
We have to abstain.
He needs to abstain for the record, right?
Yes,
Okay,
I can
Miss-
abstain for the record, correct?
There we go, there you go. Mr. Balakapalan?
Aye.
Mr.
Aye.
Pearman, Ali votes in the affirmative. Matters passed 4 yeses, 1 abstention, and so thank you for your ability to participate, Dr. Abraham, and we'll be very cognizant and conscious of the time, considering the fact that you're in the hospital with your family as we engage and conduct this hearing. Ms. Thomas?
Okay, good morning. We're swearing in 3 board members this morning for their reappointment to the
Wait
board.
1 second, Ms. Thomas. Should we do it over? Okay, so we're going to do it over for the record. This morning, Dr. Abraham is participating via the emergency circumstance provision of the California Government Code section relative to the Brown Act. And so I would ask that Dr. Abraham provide a very brief statement of the circumstances or the circumstance that disallows him to participate in person.
Sure,
via
this is
posting
Dr.
the
Jerry
agenda.
Abraham and I am dealing with a family emergency and I'm in the hospital right now.
Okay, I move that we allow Dr. Abraham to participate in today's hearing via the emergency circumstance provision of the Brown Act. Is there a second to that motion?
I'll second.
Mr. Pearman seconds. Any further question or discussion on that motion? Dr. Abraham, your vote?
Aye.
You're going to abstain for the record. You abstaining, sir? Can you hear us? Are you abstaining? Ms. Verdugo Peralta?
Aye, the lights just went out in here. There they go.
Okay. Mr. Balakapalan?
Aye.
Mr. Pearman?
Aye.
Ali votes in the affirmative. Dr. Abraham, can you hear us? To cast your vote as an abstention? Okay, so we'll come back and collect his vote subsequently, but the matter is hereby approved, 4 with 1 abstention. Ms. Thomas, the floor is yours.
So this morning, we're swearing in the 3 board members that were reappointed to the board for the term that ends June 30th, 2028. So I'd ask for Board Member Ali, Board Member Verdugo Peralta, and Board Member Abraham to stand if they can. Raise your right hand and repeat after me. I state your name.
I, Cynthia Verdugo Peralta,
Aye, Dr. Abraham.
During such times as I hold the above office,
during such times as I hold the above office,
do solemnly swear or affirm
do solemnly
Swear or affirm
that I will support and defend the Constitution of the United States
That I
that I
will
will support and defend the Constitution of the United
Constitution
States
of the United States
and the Constitution of the State of California
and the
and the
Constitution
Constitution of the State of California
against all enemies, foreign and domestic.
against all enemies,
foreign and domestic.
That I will bear true faith and allegiance
that I will bear true
I
I will
faith and
bear
allegiance
true faith and allegiance
to the Constitution of the United States
to the Constitution
Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
Without any mental
without any
reservation.
mental reservation
or purpose of evasion,
or purpose of evasion,
Purpose of evasion.
and that I will well and faithfully discharge
that I will well and faithfully discharge
the duties upon which I am about to enter.
duties upon which I'm
the
about to.
duties upon which I am about to enter.
Thank you.
All right, and Dr. Abraham, can we capture your abstention vote?
Yes, I abstain.
Thank you. All right, we're clear for the record.
Okay.
All right.
So now we move next to the elections for chair and vice chair for the next one-year term. We'll start off with the nominations for chair. Are there any nominations?
I nominate to reappoint Makai Ali.
Any further nominations? Hearing none, I will close the floor for nominations. We have Board Member Pearman nominated Board Member Ali as the chair. Is there a second?
Second,
Thank you. So we have a motion by Board Member Pearman to elect Board Member Ali as the chair and a second by Dr. Abraham. How do you vote, Dr. Abraham?
aye.
Board Member Balakabalan?
No.
Board Member Pearman?
Aye.
Board Member Verdugo Peralta?
Aye.
And Board Member Ali?
Aye.
Motion passes with 4 votes and 1 no. So next we'll move on to nominations for the vice chair. Are there any nominations?
Ali moves Pearman.
I'll second that. Sorry.
Second,
Are there any further nominations? Hearing no further nominations, I will close the floor for nominations. I'm sorry, Board Member Ali is nominated Board Member Pearman as vice chair. That was seconded by Board Member Balakabalan. So how do you vote, Board Member Abraham?
aye.
Board Member Ali?
Aye.
Board Member Balakabalan?
Aye.
Board Member Pearman?
Aye.
And Board Member Verdugo Peralta.
Aye.
Okay, motion passes 5-0.
All right, thank you. Thank you very kindly. So today, before the hearing board is a case involving Enery Holdings LLC, case number 6248-3 is an interim variance, Rule 2021. Mr. Clerk, you provided us with 2 documents. I would assume these are exhibits. So the first is an email from Michael Munoz to Thomas J. Lee, copying 2 individuals. Title is Ice Gin. No, we're just calling out the exhibits. Oh, yeah, but absolutely, come on up while we call the exhibits out. So, Mr. Lee, this will be Exhibit 1. This is dated June 11, 2025 at 12:53 p.m. Exhibit 2 is from Michael Munoz to Thomas Lee, copying 2 individuals. Subject is facility 186899 Ice Gin. The date is June 5th, 2025. The time is 1:35 p.m. This Exhibit 1 and Exhibit 2 respectively. Mr. Chair, just for the record, are there any individuals who've sought recognition to provide evidentiary testimony or general public comment online? Thank you very kindly, sir. Let the record reflect that no one has sought recognition to provide general public comment or evidentiary testimony online. Let the record also reflect that no one has sought recognition in person to provide any public testimony and or general public comment. Who do we have representing the executive office?
John L. Jones II for the executive officer.
Mr. Jones, pleasure to see you, sir. Who do we have representing Enery?
Olivia Goldstein,
Spell your last name, please. Gold.
STPIN.
Okay.
And I'm Manuel Duran. I'm the attorney for Henry. However, I'm here on a supporting role.
Okay, and you spell your last name, sir?
Duran.
Very well, very well. All right. Well, sir. All right, there you go. Okay, how many individuals do we have before the hearing board today who will be providing testimony? From the Henry side?
Can offer one individual at Warburg. He is here to testify about our communications with AT&T.
Okay, so why don't you remain standing? On the respondent side, how many individuals do you have present today?
We have one member of staff who is available if the board has questions.
Very well. And so why don't you both stand so we can administer the oath? Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? Thank you very kindly. All right, Ms. Goldstein, Mr. Pimmer, you had a comment?
Yeah, just a comment. The petitions checked regular and emergency, but I understand from the clerk and just want to confirm the actual petition mentioned, they meant to say interim and as well as regular. Is that how we should read this?
I think when we submitted to you guys, there was an email that said that they wanted to change it from emergency to interim.
Thank you for the record.
Yes.
There was an email.
Yeah, there's an email. All right, so Ms. Duran, floor is yours. I'm sorry, Ms. Goldstein, the floor is yours.
Do you want the mic on? Or-
Yes.
Okay, great. Good morning to the hearing board. My name is Olivia Goldstein. I'm here representing Inari Holdings LLC. And I'm here today because due to criminal actions by thieves stealing copper wire from AT&T, the connection to transmit data from our facility, which is Light Hype 6 IceGen to AQMD, has been severed. You can see in Appendix 1, we attached, an article in the LA Times regarding this issue. When power was restored after our March outage, we realized that we could not connect to the SEMS modem. We contacted AT&T immediately and have since been in touch with them more than 15 times, as you can see from the log of our communications with AT&T, which is in Appendix 2. AT&T indicated that they were working on the issue, but as of our last follow-up on June 24th, it is apparent that AT&T cannot repair the line in advance of our July 15th RADA test, which is scheduled in support of variance 6248-2 granted by this board. In another circumstance, if we could not transmit the data, we could remain on standby until the issue is fixed, but we don't have that option. And the reason we don't have that option is that in addition to the scheduled RADA test, our facility, IceGen, is a FERC-regulated utility, and as such, we are legally required to respond to CAISO run orders, which could happen at any time. Thus, we either violate the CAISO FERC tariff if we do not run, or we will imminently violate Rule 2012 subsection C3A if we follow CAISO's order to run. We are between a rock and a hard place. If we generate, we will not be able to transmit SEMS data within 24 hours of emission through no fault of our own, and therefore be subject to missing data procedures that far exceed the reality of our turbine use. When we informed AQMD Enforcement Inspector Thomas Lee of the inability to transmit due to third-party criminal theft, he advised IceGen that we must file a petition for variance in order to not be subject to missing data procedures for every hour of every day that the modem cannot connect. We are following that direction. We respectfully request that the board grant this variance.
Can I clarify some things, Mr. Chair? This is an interim variance, so the hearing is bifurcated. Are you aware of that, Ms. Goldstein?
Yes, I believe the next hearing is on the 28th.
No. In this hearing, we have to take the good cause provision first. And then and the 4 findings you have to make in good cause. After those findings are met and the board votes on it, then we move to the hearing for the interim.
I see.
So there are 4 findings. I don't know if you have those in front of you or what those are, and I can
Yes. let me
generally tell
see.
you what but you should have a piece of
Yes.
paper or something that,
Oh, this one here? Thank you very much.
so what I was trying to say is you need to address those 4 findings first.
Great.
And then it's same for both parties, and then we vote, and then we move on if there's a majority vote.
Okay. So in response to item A, that the petitioner for a variance is or will be in violation of section 41701 or of any rule, regulation, or order of the district, we will imminently violate Rule 2012, subsection C3A, when we cannot provide our emissions data to AQMD modem line within 24 hours of a run, which we cannot do because the line has been severed through no fault of our own. And it's imminent because not only are we scheduled for a RADA test, but if we are ordered to run by CAISO, we cannot disregard a run notice. Letter B, excuse me, that due to the conditions beyond the reasonable control of the petitioner, or requiring compliance would result in either, number 1, an arbitrary or unreasonable taking of property, or 2, the practical closing and elimination of a lawful business. If we are subject to missing data procedures, I believe that we calculated out for our summer run ending in 30 September 25, we would be forced to pay a fine of approximately $1,600,000.
Can I interrupt, Ms. Golden? You may have the wrong sheet. The good cause finding is different, slightly different.
Okay.
Yes, can we give her do we have the proper?
Yeah, clerk,
First would be the petitioner is in violation of section 41701 or of any rule. Second would be the circumstances leading to the violation could not reasonably have been avoided by petitioner.
Yes,
Okay.
yes.
Great. So we have attempted within our power to right this issue by contacting AT&T more than 15 times, as you can see in the log. We cannot fix the issue ourselves as it stems from a third party. We were told the issue would be fixed in June. It was not. We were told the issue would be fixed at the first week of July. It has not been. We now believe it will not be fixed before we must violate a regulation, and therefore we filed for this variance. Number 3, petitioner exercised diligence in petitioning for the interim variance and scheduling the interim variance hearing. So, as I said, we attempted within our power to right this issue far ahead of when we would need to have our RADA test and thus create emissions. When it became apparent that we could not, we informed Inspector Lee. Inspector Lee indicated to us that we should file for the variance, which we did. Okay, and 4, a denial of the interim variance would result in either an increase in the emissions of air pollutions, an adverse impact to the air quality, or adverse impact on public health or welfare, or B, an unreasonable and unavoidable adverse impact to petitioner. So I would just like to point out that we will not be increasing any emissions of air pollution. We hold 2 times our annual NOx credits. So this will not result in any increase in emissions. And in response to B, we calculated that if we were forced to pay missing data procedures fines for the hours and days that IceGen does not normally run, it would cost IceGen approximately $1,600,000 and result in us having to lay off our staff.
All right, thank you very kindly. Mr. Jones?
John Jones, on behalf of the executive officer, in line of the circumstances, I'll try and be brief. With respect to good cause, we don't think the showing has been made. If we look particularly at the issue of diligence, looking at the timeline that's happened here, I would direct first the board to look at Exhibit 1, where we have an email informing AQMD that the RADA test is going to be scheduled. That was on June 11th. If we take a look then at their petition, they contacted AT&T on June 12th. So we already know two things. One, AT&T told them that it was supposed to be fixed the first week of June. And two, they knew that on June 12th, that certainly hadn't happened. June 12th is a Thursday, so now we're 2 weeks into June and nothing has happened. So they already know that they need to come in. Then we have additional contacts to AT&T. We have a contact on the 17th. We have another one on the 19th. So now we have an additional 2 weeks, another week has passed, and then we have another contact to AT&T on the 20th. So now we're 3 weeks in, obviously no movement from AT&T, and still no attempt to get relief from the district. Or, I mean, it's not from the district, sorry, from the hearing board. The next instance is June 24th. They call AT&T again, still nothing. And then 2 days after that, so the 26th, almost basically the full month is gone. Then they seek relief here from this board. We don't think that shows diligence at all. I mean, they should have been in weeks ago. They knew this was an issue weeks ago, and they made no effort to do anything about it weeks ago. But that's not the only problem. If we look at Exhibit 2, direct to you, there's another email from the petitioner to AQMD informing AQMD that they're going to be doing a test firing that day. That tells us a couple of things. First, it tells us that they're already in violation of the variance that they were operating under because they're supposed to give us 72 hours notice, and they clearly didn't do that here. More importantly, though, on 6.5, because they test fired, they are no longer in the safe harbor provisions. So everything that they are seeking relief from now has already happened. They're already in violation of 2012. And the hearing board doesn't have the power to grant retroactive relief. So there's no urgency at this point. I certainly don't have a problem having this thing heard on regular notice, and we can talk about what can be done to fix the issue. But in terms of the requirements of an interim variance, the diligence shown, one, hasn't been made, and two, would be moot because they're already in violation of the rule that they're trying to seek a variance from. Thank you.
Thank you, members of the hearing board.
Mr. Chair, I think we got to hear from the witnesses. If they do have a witness, Henry, correct?
No, but, okay, hold on one second, hold on. Do you have a witness to testify in this particular element of the case, or was your witness testifying?
My witness is testifying about the AT&T, I'm sorry. My witness is testifying regarding the AT&T communication, which will address Mr. Jones' first point.
Okay. And so their testimony will be germane to this particular aspect of the.
For the first
Okay,
point, yes.
Very well, then let's bring the witness up.
Okay. This is the law, starting from your first communication here, 243.
Okay, my name is Eduardo Rodriguez. And I was the person who opened the ticket.
Sorry, can you spell and state your name and title, please?
So Miss, hold on one second, because it's a lot going on. Okay. Mrs. Balakapul, I wanted to address comments through the chair because, of course, this is her case and I want her to be able to put it on. Okay, thank you very kindly, sir. Much appreciated. So this is your witness. You will examine him, right? He's your witness, right?
Great.
So you would introduce him, et cetera, go through the process as if this were a court.
I'm not an attorney, but I will try my best.
No problem. Or the attorney can supplement, right? But he's your witness.
Okay, great. So you'll, okay. Is your mic on?
Yes.
Okay, great. Can you please state your full name, title, and spell your name for the hearing board.
My name is Eduardo Rodriguez. I'm a senior operator. My name is spelled as Eduardo, last name Rodriguez.
Thank you.
Excuse me, Mr. Chair, I didn't hear what the full title was.
Senior operator.
Thank you.
Eduardo, were you put in charge of contacting AT&T when we realized that we could not connect to the SEMS modem?
Yes,
And what day did you first contact AT&T?
April 3rd.
And what did they say?
They just created the ticket and they'll get back to me when they have further information.
And when did you follow up next?
Through the logs, you can see I followed up 1, 2, 3, 4, 5, 6 times on April 3rd, the same day that I opened the ticket.
And what were you told by the last time that you
Store
contacted
close by
AT&T
Or anything, right?
As of
on April 3rd?
Oh,
What
April
was
3rd?
on the sixth time that you called them?
That they couldn't get a technician out there, and then they had to perform a circuit test on their end remotely. And after, if they couldn't get the circuit tested fixed throughout remotely, that they would send a technician out to our site.
Okay, thank you. And when was the next time that you contacted them?
April 4th,
And what did they say then?
no progress. They still had an issue. It probably wasn't an issue with their circuit. It was something on the field.
So that's when they realized that it was not a small issue, but a larger issue that they could not resolve immediately.
Yes, I was told it was a part of a greater outage.
Did they give you a timeline for repairing the outage?
I was told, can't recall if it was that day, but I could told that it was June 1st that they would have it done.
Okay, so now we're into June. And what happened on June 1st did you call them on June 1st to ask them if the outage had been repaired? You can pull it.
Oh.
Oh, that's 4:30.
Yeah. No, I didn't make contact with them until June 12th.
Why was that?
We were pending, well, they said that they needed a wire to restore the wire, and that's the reason why they couldn't get it done. But I totally didn't recall, I didn't contact them June 1st.
And when you contacted them on June 12th, what did they say?
They're waiting for the materials, meaning the wire.
Did they give you a time frame for when they would receive the materials?
They said no estimate time of repair. They kept pushing it back to June 28th, and they just kept pushing it back. They don't have a time for repairs.
And by this time, had you scheduled the RADA test? Or had one of our other employees scheduled the RADA test?
Yes, I didn't schedule the RADA test, but someone else may have.
Okay. And in the log, it says that you contacted them on 6/17 and 6/19. And what did they say during those phone calls?
The same thing, that they have not ordered the materials, and they're waiting for wires.
Okay. And when was the next time you contacted them?
After the 19th, on the 24th.
And what did they say on the 24th?
The 24th, they said that it looks like the repairs would be done by July 31st, 2 p.m.
And at that time, what action did our team take in terms of creating a variance? Do you know?
Yeah, we contacted AQMD, notifying them.
So at the time that you were told by AT&T in no uncertain terms that that SEMS would not be restored until the end of July, which was past our RADA test, you contacted AQMD.
Not myself. No, it was not me.
Our another employee at our facility contacted AQMD?
Yes, I believe so.
Okay, thank you.
I'm checking that it's hearsay.
The objection is sustained.
Okay.
All right,
Uh,
did you want to ask another question? You want to follow up relative to that?
Yes, I do.
Go right ahead.
Please, do you know who it was who contacted AQMD?
No,
Okay. Thank you.
Thank you, Mr. Jones on cross.
Thank you, Mr. Rodriguez. Just a few questions. These logs are all calls that you made in the submittings?
yes, you can see my personal phone number there, 562, and then sometimes I call it from the actual office, the 310 number.
Okay, and I can see from this that you called regularly throughout April and then had no contact at all until June 12th.
Mhm.
Why was that?
Uh, me personally, we had other stuff to do working wise, and I didn't follow up with them about it.
I asked because this is a 6-week period and there is no point within that 6 weeks to check on their progress.
Yeah, I totally, I thought it was just, I disregarded, I forgot about it.
Did AT&T ever tell you how long it would take them to fix things once they got the copper?
As of now, my knowledge from what they're telling me is July 31st, but it was always pushed. The day was always pushed from one day to another.
Well, that part I understand. I'm asking a different. The first time you mentioned in one of these calls that they told you they hadn't gotten the copper yet.
Correct.
My question now is, once they told you, did they ever tell you when we get the copper, it'll take us a week or however many days, or was that not discussed?
No, they said once they get the copper, they'll work on it and then they'll notify me. All these times that I reached out to AT&T, it was myself reaching out to them. They never gave me a status update.
Or did they, or an ETA,
What was that?
or an estimated time once they got the copper?
After they just mentioned dates. They didn't say if we get the copper today, it'll be done in 5 days. They didn't say that.
That's what I'm trying to. Okay, thank you. And when did they inform you that it would be July 31st?
I spoke to them the 24th.
Okay. It's my understanding that.
I'm sorry. No,
Sorry.
I haven't. I made a call July 1st at 9 in the morning to get a status.
So July 1st is when they told you it would be done?
Yes, July 1st. They told me it'll be done July 31st.
Okay. Earlier in this petition, it mentions that you were given an estimate of the first week of June. Did they give you that estimate?
They did, yes.
When did they give you that estimate?
I can't recall specifically based on their notes, but it was somewhere in April or something.
Are you aware that there was a test firing done on June 5th?
Yes.
And what were the results of that test firing?
We didn't get to test fire the equipment failure.
Are you aware of what the reporting requirements after test firing has been done?
So was that again?
After a test firing has been done, there are reporting requirements. Are you familiar with those?
The transmission of the data? Yes.
And so you knew that there was a test firing on the 5th, and you also knew that you needed to, at that time, start reporting the results.
I'm aware of that, yes.
Okay. No further questions.
Thank you very kindly. Just if you are so inclined and you want to do redirect, are you okay with the hearing board asking questions?
Please feel free.
Thank you. I just want to make sure you're comfortable with the process. All right, members of the hearing board, Mr. Pearman.
Just one question, sir. At one point, you just said that the AT&T told you they needed wire. When did they make that statement to you?
That was sometime in between mid-April that they mentioned that.
All right, thank you.
I do want to also add that we had several technicians from AT&T on our site troubleshooting this problem. And one of the gentlemen told me that because this happens so much that they're not in no rush to repair the wire, because once they repair it, it gets stolen again. So
Objection hearsay.
That objection will be sustained. All right, Mr., any additional questions of the
Yes.
gentleman?
I have questions.
Ms. Verdugo Peralta.
Thank you, Mr. Chair. Mr. Rodriguez, it was mentioned earlier that AQMD was contacted, and you said that was not by you. Is that correct?
correct.
Okay, is the person here today who did speak to AQMD originally?
I have no knowledge to be exact who reached
You're,
out to.
in other words,
AQMD.
are you the only witness from Enery today?
Correct.
Okay. What date were you given? And I'm assuming that's company-wide. What was the date that was given that the AQMD inspector made your company aware that a variance had to be, or a petition had to be uh, called for, that you had to call in and contact AQMD? When was that?
That would be Friday, June 13th.
June 13th. Okay. All right. And were you part of writing up the request for the petition?
No,
For the
ma'am.
variance? You were not, okay. So you were notified by AQMD on the 13th. Who did write that? Who did fill out all of the forms for the petition? Do you know?
Can I take that one?
Yes.
That's
if you have that
our
information.
Director of Compliance, Michael Munoz.
Okay. And he's not here today.
He is not.
Okay. The question I'm having trouble with, it's not just that there's a lag of time here. My question is the fact that whether your company knows the policy of the hearing board or not. And I believe we have seen Mr. Munoz in the past, but I'm not so sure, and I wanted to be able to ask, but we can't because he's not there, if he knew that he needed to contact AQMD ASAP. Because from my point of view and from my past experience dealing with small businesses, they don't always know that they're supposed to be contacting AQMD ASAP. When something goes wrong, because you went to the source of the problem, you went to the source, which was AT&T, correct?
Yes.
Okay. But until the AQMD inspector told you you had to come and you had to contact AQMD, nobody knew that you had to contact them prior to that date? Can you answer that?
Yes, to my knowledge, yes. We didn't know we had to contact them immediately.
Okay.
Is it possible that I can jump in here? I don't want to,
If you have information that's pertinent to my question, yes.
thank you. I have a email from Mr. Lee to Mike Munoz, which was not part of the application and therefore didn't receive an appendix, but it's dated June 6th. And in that email, Mr. Lee tells Mr. Munoz that regarding the SEMS data transmittals, there are limited options. And the first option is to apply the missing data procedures. And the second option would be to file a variance. They then have further communications culminating on June 13th, as Eduardo said, and the petition for variance was filed on June 26th.
So 20 days later?
Well, I think more like 13 days after Mike got confirmation about what he needed to do from Inspector Lee.
Well, in that email on June the 6th, isn't he telling him right there, one of the options, number 2, is to file a variance?
He does say that one of the options is to file a variance.
Okay, so
and I
that's
believe
notification right there, is that not?
It is. Then Michael responded on June 6th with questions, follow-up questions to Mr. Lee. And Mr. Lee responded, let me see, on, sorry. The 13th. So the lag between the 6th and the 13th was waiting for a follow-up response from Mr. Lee.
However, on the 6th, item number 2, Mr. Lee was notifying Mr. Munoz that that was an option. That
He did
was,
notify, yes, he did. And
Okay,
Michael
so-
responded immediately asking for clarification, which he did not receive until the 13th.
I don't know what's clearer than you need to file a variance. That's one of the options. How clear can you get beyond that?
As I was not a party to the emails, I can't speak for Mr. Munoz. Yes, he did say that you could file for a variance. And yes, I know that Michael asked him what specifically would we be filing a variance over? And can you elaborate on the relief that we're seeking? And then Mr. Lee responded on the 13th.
Okay, those are all the questions I have at this point. Thank you.
Thank you, Mr. Balakapalan.
Mr. Chair, Ms. Goldstein is reading from some email that she wants, I think if we want to consider that as evidence, you need to submit it to the
I'd be
clerk.
happy to, and I apologize.
No
It
problem.
it was not included in the,
Can we do that? And so give us a few minutes to read it and verify the communication.
Do you have ample copies of that? Because the respondent was not privy.
I do not. I received a forward of that email this morning. I apologize.
And
What is the date of the email?
It is June 13th. The chain starts on June 6th and ends on June 13th.
Oh, okay. Well, yeah.
Like 5 minutes.
Yeah.
well, so what we'll do is we are going to take, how much time? Okay, so we're gonna go on recess. We'll come back at 10, why don't we just say we come back at 11 o'clock?
Thank you.
Okay, we're gonna recess. We're off the record until 11 a.m.
Please email me that exhibit.
Yes, we'll make sure because we want to be able to get everybody the exhibit
Thank you.
as well as review it.
You muted, so you want to ask again?
All right, Mr. Day, we're back on the record. Back on the record at 11:02 a.m. Okay, Mr. Clerk, you provided us with a new document, a new exhibit, and so this exhibit will be Exhibit 3.
No. To be a.
I believe it would be exhibit 5.
No, they're letters.
Okay, so then this will be Exhibit A. This is A.
For clarification, did you mark this the? You submitted petition, did you mark?
I thought we were supposed to have a copy.
So we'll mark this one as A then.
Okay. All right, so we're marking the email from Michael Munoz to Olivia Goldstein, Emmanuel Duran, dated Tuesday, July 1st, 2025 at 11:36 p.m. And there's a host of other emails attached. Thomas Lee.
You know what? I'm sorry, I got the exhibit. He marked, he had put 1 to 1 and 2 on his.
Right, he's alphabets, right.
Yeah, there
Right,
could be.
that's what I was asking.
He put 1.
Yes, so.
My mistake.
So, no, that's why I thought these exhibits were from the petitioner. Okay, so just to be very clear, the initial exhibits as proffered by the district are A. Exhibit 1 that I said is A, and Exhibit 2 is B. On the Enery side, the document I just referenced, the communication between Michael Munoz, Olivia Goldstein, dated July 1st, 2025, 11:36 p.m. That's now Exhibit 1. Okay, so we've had a sufficient amount of time to review the various exhibits. So, members of the hearing board, what is your pleasure?
I had some questions for Mr. Rodriguez.
Absolutely, the floor is yours.
Mr. Rodriguez, your role has been mainly communicating with the AT&T staff,
Correct.
and you have nothing to do with the correspondence with the AQMD inspector or filing variants and so forth.
Correct.
So this evidence, I mean, this Exhibit 1 is sort of you have no direct knowledge of this, right?
No, sir.
Okay, you were just reading what was provided to you. Okay, now, when did you finally find out? When was that it'll be restored by the end of July?
That was July 1st.
July 1st, okay. And prior to that, you were not given a definite date?
No.
Okay,
They just always give you a date and then they just extend it because of the material not being available.
but it was known there was a problem way back in May, right?
Yes.
Okay. And when you say you're senior operator, what are you in charge of? What do you do at the Enery?
Basically, I operate the machinery, the turbines, and also do preventive maintenance on the equipment.
And you mentioned the test run, it was not successful or it didn't run that day?
No, we weren't able to. We had failure with something in our system.
I'm sorry, were you able to run the generator
No, sir.
at all? No.
No,
Have you subsequently run it at all?
no.
It's still, but it's not, the flange have been removed though.
Yes,
Okay, but you have not operated the equipment yet.
no,
So to your knowledge, the next time it will be operated is when you do the radar test?
correct.
Okay. Okay, I have no further questions. Thank you.
All right, down to closing statements.
Mr.
Oh, I'm sorry, Ms. Verdugo, proud to the floor is
Yes.
yours.
Thank you. Based on the fact that this is addressed to Ms. Goldstein, I'm going to ask Ms. Goldstein, you were not made aware of this until yesterday, correct?
That's correct.
Okay, so, and I'm assuming that you read it. And when you did read it, did you not, especially on the, let me see, this would be Mr. this would be the inspector's response to Mr. Munoz on the second, it's still part of page 1, where Mr. Munoz was trying to call out the fact that, Rule 2012, that's what he was basically using as his excuse of why he hadn't done anything so far as contacting the AQMD. However, Mr. Lee goes on to explain why he needed to. Now, I'm assuming that you read that. Did you not either take issue with it, or did you not take that as, yes, that's what should have been done?
I'm sorry, Mr. Chair. Are we asking?
I'm asking Ms. Goldstein
To
about
testify? Because she's the
she's
attorney.
already, this document was written and given to her as of yesterday. And that's what brought this up, is because I started asking questions of where and when. And
So-
that's why we're
so-
ending up with this exhibit.
So just for the record, Ms. Goldstein is not the attorney.
Right. She's,
That's correct. I'm not an
Mr.
attorney.
Right, she's not
I'm
the
the
attorney.
representative.
She's not. Mr. Duran is the attorney.
Correct.
And so to Mr. Balakapalan's point, you can in fact clarify, or you can assume the oath and testify. What do you feel more comfortable doing?
Whichever the board would prefer.
Okay, so I believe with respect to the line of questioning, Mrs. Verdugo Peralta is proffering, I believe it might be in your best interest to assume the oath.
Okay.
So while I go ahead and administer that now, why don't you stand, please? And again, just so we're clear for the record, this is a little bit out of character because we received this document literally 35, 40 minutes ago. And so we've had a chance to review this. And of course, you're in the direct line, you and the attorney in the direct line of this email. So, all right, raise your right hand. Do you affirm that the testimony that you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very kindly. All right. Okay, Ms. Verdugo Peralta, you've heard her questions, Ms. Goldstein.
Yes,
And
could I
so-
ask Ms. Verdugo Peralta to please re-ask the question?
Okay.
okay, so if you're looking at the document and this is, let's see, I guess this is now page 2, where Mr. Lee is countering what Mr. Munoz seems to have understood, that he didn't need to contact the AQMD based on the SIMs being offline, but yet Mr. Lee goes on to explain to him why he needs to file a variance. And to me, he went into great detail of why he needed to file a grievance or a variance, but yet you're stating that it wasn't filed until, what was the date on here? The 26th of June? Because there was not an understanding that it needed to be filed. This flies right in the face of that.
My understanding from reading this document is that the email that Mr. Jones provided as exhibit, is that B? B, I believe, which is the first email in this chain, occurred on June 5th. And Mr. Lee, and at that, from the reading of this, at that date, Mr. Munoz asked, if we don't have access to the SEMS modem, how do we report? And Mr. Lee said, the options are apply missing data procedures or file a variance. And in further reading, Michael responded immediately on the 6th and said that he didn't understand certain things. Now, I can't speak for him.
No, I
Because it will be
understand. You
hearsay,
cannot speak for him.
but he asked these questions. He was not given a response until he followed up on June 11th, and then he was given a response by Mr. Lee on June 13th, which was a Friday, if I recall correctly. After that, when Mr. Lee told him he would have to file a variance, he began to work on it and compile his documentation. he then filed the variance on the 26th.
However, Ms. Goldstein, the date of June the 13th is when Mr. Lee is letting Mr. Munoz know that he should be filing a variance. And at that point in time, at that moment, somebody should have picked up the phone and called the AQMD and said, you know what, we're going to file a variance. We'll need to put it together, so on and so forth. But you're still notifying the AQMD that you are aware that there's a problem and that you need to do something about it. And I can see where Mr. Jones is saying there's a lag of time in there. You know, we're not giving you time to, how long does it take for you to fill it out? You need to notify the AQMD ASAP. When the moment that there's a problem, you contact the AQMD. That doesn't mean we expect the paper in that day. That means you're notifying us that there's a problem. And that's exactly what Mr. Lee did in this document.
And I would say that Mr. Munoz did notify AQMD and asked for recourse and then had additional questions, which he followed up in a timely manner. And then there were days of lag until he heard back with a more in-depth response from Mr. Lee. At the same time, we believed, we had no reason to doubt that AT&T would be working on this issue until it became apparent that they would not be fixing the issue by the time we were supposed to run our RADA test.
You're missing the point. The point is when your company became aware that they could not perform something that the AQMD required you to do. At that point, it's not the responsibility of AT&T to contact us. It's your responsibility to contact the AQMD. And he's telling you right there, as plain as day, in that document that's dated the 13th. And the word timely is very key here because of the fact that it wasn't done on the 13th or even on the 14th. You waited, another, what was it? 12 days or so? So that's where I am having a problem granting the first part of this variance, because the good cause part is always about the timing. And when you were notified, when you became aware of the fact, and when you notified AQMD. And that should have been on that date, according to this email. If Mr. Lee had not responded and it went even further and given you a further explanation of why, maybe I could follow your thought process on this, but right now, I can't. And I normally am very supportive of small businesses because they don't normally know what the process is with the hearing board. And it is a little difficult, but if the inspector is telling you, and he's from AQMD, file a variance, then that's what should have been done. I have nothing further.
All right, we're going to move down to closing arguments. Ms. Goldstein?
Mr. Chair, since Ms. Wilson's testify, I had a follow-up question for her.
So we're going to allow one follow-up question, and then we're going to move to closing, because at this point, the board we need to move to a point of making a decision.
Jones has questions.
No. You ask your questions, and if Ms. Jones has questions, then we'll recognize them accordingly. So but we're going to land this plane before 11:30. Go right ahead, Mr. Balakapalan.
Well, what's your position at the facility?
I'm the president of ANERI.
Okay. And so you've been in communication with Mr. Munoz regarding this issue?
When there's an issue like requiring my appearance today, yes.
And what about preparing a timeline? Because we're not getting do you have a prepared time? You obviously don't have a prepared timeline of a sequence of events that occurred, correct?
No, I was not made aware of the issue until I was notified by Mr. Munoz, who's our compliance director, that he would be unable to make this meeting and I would need to step in on his behalf.
But he did not prepare anything and give it to you.
He prepared the petition for variance as well as the appendices that were attached 1 through 4 which were distributed. And then last night forwarded what would be, I can't remember what we called it, but the email that we were reading from just now between Mr. Munoz and Mr. Lee.
Okay. So you don't know exactly when he was made, I mean, besides, so looking at that exhibit 1, on the earliest, he was notified by AQMD inspector for June 6th, June 5th, right?
I believe it was June 6th.
6th.
Yeah.
And the inspector told him about the variance.
Yes, from reading the emails, that's what I glean.
All right, I have no other questions. Thank you.
Mr. Jones, just to be clear, you have any cross-examination?
I have no questions.
Thank you, sir. All right, closing. Ms. Goldstein or Mr. Duran, closing arguments?
Okay, so thank you to the board for hearing our petition for variance. As mentioned previously, we believe that we did file this in a timely manner once we were made aware that a petition for variance would be the only other solution to the issue that we're facing with AT&T, other than having missing data procedures apply, which, as I mentioned, would cause us large economic harm. I do want to address I apologize because I can't keep these exhibits straight, but the exhibit given to the board by Mr. Jones, where Mr. Munoz emailed Mr. Lee about having the flanges removed. Mr. Jones indicated that because of that, he believes that we are in violation of our current variance. We object to that because we thought there was another method for giving verification of data, which I have highlighted for myself, and I'm happy to share. This is Rule 2012 subsection D2B that states that there is an option to use a district internet website to report the total monthly mass emissions of NOx to the district central NOx station. So we believe that there was an alternate to reporting our data. When Mr. Munoz emailed Mr. Lee to ask about alternates, and Mr. Lee said that the only options were to go for a variance or to have missing data procedures apply, that's when we asked for clarification. And that has now come to where we are now with the petition for variance here in front of the board. Anything you'd like to add?
No.
Okay. Thank you for
Thank
your
you.
time.
Mr. Jones?
Thank you. I'll start with the last point. And with respect to the violation of the current variance, as the hearing board is aware, item 3 of the order that was issued states, petitioners shall notify the South Coast AQMD no later than 72 hours prior to starting up the gas turbine engine. We have an email on 6/5 saying, I just did that. We did not get notice prior to that time. So that's the violation, just to start with. Then we have on June 6th, we have our district staff stating, these are your options. We don't hear, and they're very clear. 6/11, so we're into the next week now. Then he says, well, I don't understand. And he lists his argument. And June 13th, we have what I think is an extremely detailed response to every reason why he thinks that these rules don't apply. So on June 13th, he knows without question that they are in violation not only of the prior variance, but of the rule 2012. They were supposed to be submitting these data procedure emissions numbers. They haven't been doing it. They need to seek some kind of relief. They haven't done it. They've been told no uncertain terms. They need to get relief. They didn't do it. We see, so weeks later, they come to us, to this board, weeks later. It's not diligence. And even if it was diligence, you can't retroactively wipe away the missing data requirements that they're subject to up to that point, which started June 5th. So there's no urgency. They've already violated the rule. We don't have a problem with them being heard on proper notice. Let's come back. They have a hearing, I think, at the end of the month. We can come back and talk about what to do. In other cases, we might be able to fashion some kind of remedy. But in terms of an emergency, exigent circumstances, whatever language you like to use, they simply haven't met that burden. They waited way too long before coming here, and they knew better. We told them in no uncertain terms how to do it. They didn't do it, and for those reasons, we oppose a good cause finding, and that's, I think, we should come back at the end of the month and talk about the merits at that time. Thank you.
All right, we're gonna,
Can I ask a question?
go right ahead, Mr. Kramer.
So you started by saying, with respect to the previous variance we granted, that was the violation, which implied that was the only violation that triggered the statement from Mr. Lee that they need a variance.
Oh.
But then you went on to talk about these other rules, so kind of be clear to me.
Oh, sorry. I'll clarify. There are two problems. One, I'm just alerting the board to the fact that they violated the variance that they're currently operating under. That aside, ignore that. They still have the additional issue, the additional violation of Rule 2012 by not reporting the data. That's the main issue. The reason we're here today is because of the data reporting requirements. They knew about those on June 6th, at least. Those are the points I was trying to make.
Thanks.
Can I just add something? How? can that be-
Generally, this would not happen,
Right,
but
I
we're gonna go
understand
ahead
that.
and we're gonna let it
Yeah.
happen.
How can that be done? It's impossible for them to be able to report with the lack of that copper wiring. I understand the argument about diligence, but usually diligence is something that's far more in time. 12 days. What's 12 days? That's 2 weeks. A lot of times when you go before a court and someone's not diligent, they sat on it for months. This isn't months, this is days. And this is something that it's impossible for them to comply with because of the copper wire situation. And we need some type of solution. And there's no reason why we can't have a solution now. Come back, at the end of the month, and there's going to be more time wasted on this issue. A solution needs to be found here.
Thank you. Members of the hearing board on deliberation. I mean, we've discussed it quite a bit, so we should be ready to vote. But anyway, are there any members of the board desirous of providing any further comments relative to this matter? And if not, then I'll lay a motion on the table. Mr. Bullock, do you have comments, sir?
Yeah.
No, go right ahead.
We're going to go.
The floor is yours. The floor is yours.
Was mine, thank you. I think that the finding we have to make in this phase, the good cause is, there are 4 findings, and I'll go through just each one of them. The petitioner is in violation, or violation is imminent, which we agree with. If they start up for the testing to do the radar testing on the July 15, they will be in violation because of the missing, they cannot transmit the data. And the circumstances leading to violation cannot be avoided, in sufficient time to provide public notice. That part, I think we all know that the circumstances leading to the violation is due to the theft of the wires. There's no question about it. There's no means to communicate. The data has been collected, but there's no means to communicate. The portion that is I'm having a difficulty is whether you exercise diligent filing. And the diligent in our guidelines, basically, basically says this on a case-by-case basis. But as soon as it's feasible, it's determined the violation is occurring or going or likely to occur. So as early as June 6th, even prior to that, there was information that there may be a problem because Mr. Rodriguez had been in communication. There was not been, AT&T has not been very responsive to the situation. So While there's no bright line definition of days or weeks, but the petitioner is required to provide, to file as soon as he knows, within even a minimal amount of information, just file the petition, which I think now it'll finally file on June 26th. So that's about 20 days after when he was first informed that he may have, that's an option. And Mr. Munez is not here, but he has been here before. He knows, I like to think he knew the procedure and before he came through, before also on an interim. And while we did find at that time good cause and proceeded and granted the variance, but this time I'm having difficulty in finding that diligence in petitioning. That it at a minimum from June 6th, it should have been filed much sooner than now. So that's the problem I have. So for that reason, I'm going to, if there's a motion, I'm going to support denying this good cause, not the merits of the thing, but just the good cause portion of it, because I don't find you a diligent petitioning.
All right, thank you very kindly. Any further questions or comments? All right, in the matter of Eneri Holdings LLC, facility ID number 186899, I move that we dismiss the petition for interim variance without prejudice for failure of the board to find good cause to hold a hearing in absence of notice to the public. And the specific finding in this matter will be petitioner was not diligent in filing. Is there a second to the motion?
Second.
Second by Ms. Verdugo Prouch. Any further question or discussion on that motion? Hearing none. Dr. Abraham.
Aye.
Verdugo Prouta.
Aye.
Balaka Palan.
Aye.
Pierman.
Aye.
Ali votes in the affirmative. So what that vote essentially means is we are unable to find good cause to proceed forward in absence of public notice. So we would, Mr. Jones, did you want to make any comments?
Only that they have a regular variance that
Yes.
has been scheduled. So
Raise a regular variance. And so any other comments from the Eneri side before we adjourn?
Guess we'll see you at the next one.
Yeah, Mr.
And I was just going to say, we really need better preparation on the procedure and or the bearing the 6 findings that have been made, and maybe on the problems, technical difficulties, and so forth that is experienced in transmitting the data, and the solutions, any solutions that you can provide for the board to consider.
I'm sorry, can you clarify? Are you asking us to provide a potential solution for transmitting data to AQMD?
I'm saying that would be helpful. Let me put
Okay.
that.
Okay, so at our hearing at the end of the month, that's something that the board will be looking for.
Yeah, and
Well, that's something he's looking.
That's something.
That's what I'm looking for,
That's
yeah.
something that he would
Yeah.
want to see. And so I would tell you to his point, I would definitely put your case together accordingly. But I would strongly and emphatically encourage you to have a detailed timeline and all parties present to testify, all parties, Mr. Munoz et al. Because it's very difficult for members of the hearing board have questions and the individual who is the principal or the subject matter expert is not around in order to answer those questions. All right?
Understood, thank you.
Good deal. At this time, we are moving to adjourn at 11:31 a.m. and off the record.
Thank you.
Yeah.